Okay, so sanctions.
Sanctions.
Read all about it. Hot off the press. 3 sanctions orders.
Let me talk about sanctions.
Okay, talk about
sanctions. I'm going to
sanctions.
tell you about my first sanction order.
Yeah.
It was in the very mid, I guess, 90s. Was I working with Pat? I was working with Pat LaPlay. And I had this small case that was going to trial. And because I hadn't done small cases. The defense firm I worked for before I became a plaintiff lawyer just did big cases. So I kind of went in reverse. When I started working with Pat LaPlay, we were going to put on this seminar called How to Hammer Allstate because they were horrible at the time. So I had to have a small case, which I didn't have one because I was going to give a speech. So I got a small case because one of my clients in an employment discrimination case was rear-ended. And Allstate said, you can't be injured, you already had an injury, and there's no dent to your bumper. So I went to trial on that, and they denied liability up until the time they got to trial, and they said we admit liability. So I asked for sanctions because the whole time I had to prove, that the other person was at fault for hitting her, and they said no, and it was a modest verdict, but it was good enough. So the judge said no, he wasn't going to give me sanctions. So I appealed because it was a district court. You could file a small case in district court. I appealed it at the Superior Court, reversed that judge and granted me sanctions and against Allstate for doing that. And with that money, I bought the picture that is in my office of the warrior woman over my desk. I still have it.
So you took, well, what did they do that was bad? Like, why would you? I part of what I don't understand about sanctions is that, like, what does it take to get a judge to convince a judge to say, you know what, it's time to punish this person?
They used to give sanctions more often back in the day.
Okay.
You violate a rule, you're supposed to follow the rules.
Okay.
And then it's kind of gotten really pretty loosey-goosey.
What do you mean, loosey-goosey?
Oh, like, for example, tried a case, 2.5 years ago now, where 3 weeks before trial, the defendants identified 3 experts who they had never identified before. And the court didn't feel that they could strike those experts because of some case law called Burnett. And so he allowed them to have those late experts. So that's an example of, I didn't get sanctions. And what's really interesting is one of the cases that we're going to talk about today, not only did they get sanctions, they got a ton of sanctions.
Well, okay, so when you talk about case law, you're talking about judges don't want to take away a person's right to put on evidence. That's important to them, right? And then but I'm a defense lawyer, imagine, and I go okay, Koehler is trying the case, and I know what her case is, and I know what her experts are going to say. She's been telling me about her whole case because she's been following the rules. And at the last minute, I'm going to be as a lawyer, oh, by the way, I got a new expert.
3 of them.
3 of them. And then you go, bollocks. That's not fair. You can't do that to me. And then I go, Judge, Mike just indicated to me that I'm being very loud this morning.
You are allowed.
I know. Okay. Bringing him down a few octaves. And then I get all excited and I go, that's not fair. And then, wait, no, you get all excited and you go, that's not fair. You put out these experts. And I say, but Judge, this evidence is so important for the jury to hear. You can't take them away. Yeah. I mean, that's unfair. How do you get around that?
So in that case, they'd actually had asked for a continuance of the whole trial. So they'd already gotten a continuance to do more discovery. This is all about sanctions that involve discovery. So they've been allowed to do more discovery, and all they did was take my client's mother's step and retook my client's step. So they take it again. They didn't take any other things. They and then they just disclose these expert opinions. So there's a rule called CR 26, which says it, at least in our state, that I needed to answer your questions and you need to answer my questions about what's the case about, what are you claiming, who's going to testify. And then that allows us to be kind of somewhat on an even playing field, supposedly. And then we can do our due diligence and then be ready so that by the time we go to trial, we're prepared. basically. But when one person hides the ball all the time, and it's almost always a defense.
Yeah.
I can tell you, I have been sanctioned before, and never for discovery violation.
Okay. But losing that trial date, how hard is it right now to get a new trial date? Yeah. Like, getting into a trial, first of all.
It was like a 6-month continuance, but sometimes it's years.
That's crazy. Mm-hmm. And do a lot of judges let this happen?
They got their continuance, and then they still didn't disclose their experts for until 3 weeks before the trial.
What's the purpose of the rule then, if you're going to let people behave this way?
I know, that's what we're going to talk about, sanctions.
Read all about it. Okay, so let's talk about judges that stepped up and did something.
Okay, first of all, please step up if you're a judge and make, I'm going to just say it, make the defendants follow the rules. The plaintiffs, okay, so here's how it goes. I don't even know if we have some of our discovery, but we'll say stuff like, tell us your name, your address. You're supposed to identify yourself. Who are our witnesses? In the case we have right now with Amazon, it's like, tell us your insurance. And they ask us questions like, well, tell us all your employment information. We list it all down. That way they can go subpoena all those people. Tell us all your medical providers. We list it down. Tell us your education, or, the deceased. We list it all out. In fact, I have a practice where I really try not to object at all, because I do want to give them everything, because that's fair. The objections we get from the defense lawyers are they're like this, they're the whole answer is the objection normally. So I'm like, give us your insurance policy, which you're supposed to give according to the rules. And they're like, objection. I don't even know what the objections
relevant, scope. Not this, not that.
Designed to lead to whatever. And then, by the way, just look at the other defendant's answer to theirs, and that's what our answer is what their answer is.
And but their objections, I fall asleep when I start to read them, because it's I don't know what it is, but they're repetitive. It seems like they cut and paste the same objections over and over again. But judges let them get away with it. And that's a problem. Unfortunately, in my experience, the majority of the judges in the superior courts allow these defendants to get away with it. And what you do is you're teaching behavior, you're affirming their behavior. And so when they're affirmed the simple stuff, they do what they did to you. They forced your case out a year and delay the case. And right now, King County Superior Court, Karen, there's so many cases ready to go to trial, and they're complaining about it. There's complaints on everyone's side. One thing the judges do could get discovery moving. Those would get the cases resolved.
Yes, the judge, it's ultimately the judge's issues, but the appellate courts haven't been really great.
You mean the appellate courts?
They haven't, yeah. So the judges don't want to be reversed.
I see. So if they punish them, they're worried about getting reversed.
Yeah. Okay, first of all, judge has no skin in the game. So nothing's going to happen to the judge. But it's reputational, I guess. It's like a mediator who keeps track of, I got this case settled, but this one's didn't. Or, I don't know. I don't know what it is. I guess it's ego and not the best interest involved in the case. Because if I'm looking at the case and I'm looking at someone that withheld discovery and didn't give it until the eve of trial, I want to do something about it. The Court of Appeals made that a little bit difficult, but there's at least one order here where the judge did everything he could in drafting his findings to show the Court of Appeals why he should be upheld.
Yeah. This was, I think...
Well, which one are we going to talk about?
Well, we can talk about...
Well, let's talk about the first one, which is it the Amazon case?
The Amazon case.
Our Amazon case.
Okay, we can talk about that.
Okay, so how many motions for sanctions have we brought on that?
We brought one motion for sanctions and contempt. We got the sanctions, and then we've recently filed a second motion for sanctions. But we have brought, I think, three motions to compel.
Yeah.
In the court, and we've had 25 or 30 discovery conferences. And you were super smart in suggesting, hey, why don't you propose, Mo, to record the conferences on Zoom. And then I proposed that. And they were like, no, you don't want to record it. And then I moved the judge to say, Judge, you order recording these things because it'll help resolve the discovery problems. And the judge is like, and they came in, they're like, Judge, we're good. We're going to trust us and we're going to be good. And then they weren't. So then when we went back and got the sanctions order, and they were complaining a little bit about what we were saying in the conferences, I was like, they can't complain. That's why I offered to record it. And they didn't. It really helped.
Yeah. I mean, why wouldn't you record those discovery conferences?
Because they don't want to
We've been saying, so you have to have a discovery conference anytime that there's a dispute before you bring a motion. And we've been asking the defense to stipulate that they should all be recorded. And none of them will agree to it.
Why do you think they don't want
it?
Tell them why. Because
they don't want anybody to know how obstructionist they are.
That's right. Mm-hmm. Obstructionists. So we got an order here for fees. Okay. For getting discovery in the middle of Christmas. And discovery that was relevant for a 30B6 deposition. It was crazy. They dumped like 7,000 pages of discovery on us. And I had to spend Christmas reviewing it. I was so angry. And so we filed the motion for sanctions and contempt. And all I did was go up to the judge, and I was just like, I am frustrated. I spent my Christmas reading discovery to prepare for this deposition, and either they had all this stuff in their pocket and disclosed it at the last second, or they intentionally withheld it. And the reason I know that is that as soon as I filed the motion, they dumped the 7,000 pages of discovery. It means they had it.
Yeah, they had it.
And so the judge was not having it.
Like they dumped it the next day. We filed the motion that they were withholding documents, and like it was the next day. It was either the next day or the day after the next day, but it was like that same week, within a day, they just dumped it.
I mean, this is it's the judge basically said he had ordered. Here's what the judge said. Amazon did not have a satisfactory explanation about why the thousands of pages of documents that were produced December 20th, 24th, after plaintiff filed their second motion to compel and for contempt and sanctions, could not have been provided to plaintiffs sooner, especially given the court's order required Amazon to comply within 30 days of the October 23rd order. That's basically saying, what? What does that mean? Did not have satisfactory. What does that mean?
And I forgot to mention that. So we filed a motion. They dump the documents. They then call us. Remember that? Well, or they never call us. They email everything. And they want us to drop the motion because they gave us all the documents. And we're like, we're not dropping the motion or for sanctions. You gave us the document, but we had to take all the time to draft this motion. No, we're not going to do it. And didn't they just argue that we were wasting the court's time, basically by making you even go down to court because they'd already given the documents?
Yes, that's one of the arguments.
Yeah, that was like, well, we've already given it to them.
Well, I know. I mean, we had already. Well, I guess what's great about this judge is that this judge.
And let's name this judge.
Honorable Grant Blinn.
Thank you, Judge Glenn.
Judge Blinn. Judge Blinn is fantastic, thoughtful, really smart. And you know what I love about his courtroom?
It's Pierce County.
Pierce County. What I love about his courtroom, when I go in there, he's always smiling. And so first thing I always say to him is, good morning, happy Friday, because Fridays are his hearings and you can see him light up. But very thoughtful judge, very fair judge. And so this is an example of somebody who steps up and does what's right and holds her feet to the fire.
Well, let me just say one more thing about this judge. There have been so many discovery disputes in this case.
Yeah.
So much withheld, so many conferences. When Mo has gone down there before on other motions, like the one that I'll never forget is the judge said, okay, I'm going to handle this at the end of the calendar, heard all the other motions, and then spent 2 hours. Wasn't it 2 hours?
Well, it was about 2 hours, hour to 2 hours, going through every discovery response and saying, turn it over. And I just was like, lighting up inside.
I mean, what judge will do that? So what most judges do is they'll say, well, we want a special discovery judge.
No, and you know what?
It's so much better if you don't have to do that, because then the judge knows, and the judge is more likely to do what happened here. And they're more scared of a judge than they are with a retired judge, frankly.
Yeah. All right, so now I want to talk about, and I want you to talk about this other case, which is Rose versus Pharmacia. And I think this is Colleen's case, who's, I believe it is, I don't know. But this is the case of a law firm.
Well, let's just talk about one little thing here.
What the little thing?
There is a commonality to the 3 different cases and 3 different sanction orders that we're talking about today.
Okay, what is the commonality?
What do you think?
They're all defense?
What kind of defense?
What do you mean? What kind of?
It's all the same law firm.
I don't think. No. I don't think. No, one of them is not. One of them is Cousin O'Connor, and the other 2 are the same law firm.
Oh well, okay, well.
Yeah.
Excuse me, I got them mixed up.
Yeah, I know. They're also. That's the part, Mike. You know what the tough part of practicing law is?
No.
Is that these law firms, like the names, Bob, Sally, Dan, like it's like so many of them. Right? And I'm not trying to, this is why I always say strip matter. Like it's hard for me to go Kessler, Koehler, more. Like I know it's not trying to be disrespectful, but it's like like one of them is called Favros, and I keep calling them Mentos, like the fresh maker, because like it's just okay. Sorry.
I know it's the first initial of all of their names.
Okay, so 2 of them.
Ours is.
Yes.
It was much longer when I started. We had 5 names when I started.
There's always been a big deal about like who gets their name on the firm and all.
Well, what we say when we answer the phone, 5 names. People have hung up before you stop talking.
But the thing is, like, the reason is because some of the lawyers, like they
insist that their name
wanted their whole name on there.
No.
No, this is a whole thing.
Wait, did you really make him?
I did.
Pick up the phone and say
this was a whole real deal.
Well, I didn't know. I had no idea when I started, so I thought that I had to do that. I wasn't the receptionist. I just had to cover every once in a while. But I'd be like,
Mike, you did. There were instructions.
I'd be like, am I supposed to say?
I'm sorry. This is so ridiculous.
It's so true.
It's so ridiculous. This is insanity. Okay, all right. We digressed. And I'm like tearing up laughing. But okay. 2 of the orders have to do with the same law firm. One is ours, and then this is the big meat potato.
Oh, save that one for the end.
Okay, all right.
Do the one about ours. Who's the attorney?
The attorneys were Wilson and Alser. He did not name the attorneys, and the judge was very careful and said the attorneys were very ethical in the case.
Which case? Our case?
Our case. But subsequently now, a new firm has jumped on to save the day, and it's Cora Cronin. And here we come to save the day. I mean, that's what they're doing.
It's going to be so much better that we're on this case. You're going to, we got this, things will get way better now. We will, we're here, we'll take charge, and, we're the best.
Number 1. And so they've now taken over the case, and the discovery issues have just gotten worse.
Who is the lead attorney?
What is his name?
Foghorn Leghorn. I'm giving you a clue. Foghorn Leghorn.
Oh, Steve Fogg. That's right. Sorry. I'm sorry I don't remember the names. But yeah, that's the lead. But he's very quiet. He doesn't say much. He doesn't say much. I don't see any correspondence. He's got a lot. He's got I think 4 or 5 attorneys under him that are.
Oh my gosh. Let me just say, we started doing depositions of lay witnesses, not medical, no experts, but the lay witnesses last month. And the first three witnesses were covered by 3 attorneys. And I was thinking, maybe I'm just not paying attention because I don't know who they are. In fact, they had never appeared in the case. They weren't on our email distributions. They're just like, there's so many attorneys. That was in addition to like the other 3. So there's at least 6 attorneys on it from that firm, not counting the other attorneys. And those are the only ones we know about. We don't know the under ones.
So there's probably even more attorneys?
Oh, for sure.
Oh my goodness.
Who knows how many attorneys?
Like an army of attorneys?
One of them's name is Boom Boom, which I approve of that.
Wait, Boom Boom?
Boom Boom.
Boom?
Boom
Boom?
Boom. Boom. I approve of that.
Like, okay, that's fair because some people call me Momo. I mean, like, hey, Momo. Okay.
I had never seen Boom Boom. I just saw his name and it said Boom Boom. And I was like, well, who's that? He was a silent witness to these other people.
Oh, that's super interesting.
Yeah. Wait, who's Lucio with?
Lucio's with Cora Cronin.
Yeah.
He's the one who has been tasked with running a lot of the discoveries.
Yeah, so let's just talk here. Like, let's get personal. Mo is like, Lucio should be a plaintiff lawyer. And now, initially I thought, well, maybe he should be. And now, absolutely not.
Okay, I push back here.
You have been ruined. He's been ruined. He's been Corcoranized. And he is done.
No, he is being taken advantage of.
No.
Karen,
he is willing to do that stuff for the evil ones.
Karen, my instincts tell me that this is a good kid.
Mo loves everybody.
No, I don't love everybody.
You do.
No. I don't love everybody. That's incorrect. Right. I get angry at people.
Only after they've hurt you.
Or hurt people I care about.
So he hasn't had an opportunity to completely fail in front of you. I'm telling you, he's been Corcoranized, and once you're Corcoranized, like, sorry.
I think every soul is worthy of salvation, and I think so is Lucio's soul, and that one day he shall be saved.
All right. Well, in addition to our case where they got sanctioned,
yes,
they got super sanctioned again.
Well, yes. Well, the firm did not get sanctioned in our case. No. The client did.
Yes.
But in the case that you're talking about...
Pull it up.
I'll pull it up.
Okay, wait.
Okay.
Let me see it.
All right, you got to look at it.
This is Judge Michael Ryan. My new hero of the judge. Michael Ryan in the case of Rose versus Pharmacia. Date of order, March 17, 2025.
Boy, that's like a week ago.
This order is 28 pages long. Look at it.
That's a lot of writing.
The judge felt so strongly about this that they did a totally 28-page order.
If this was a book of poems, it would be a chapbook. It would what we called a chapbook, Mike.
So the judge had already ordered sanctions.
Yes.
Of $1 million.
Wait, I don't think he ordered $1 million in that case.
This is not the $1 million.
That's not the $1 million.
Okay, never mind.
Koehler, you got to get the orders right.
That was totally wrong. I totally retract everything I just said about how much it was.
Yes.
That was not the right one.
Check with me, please. Before you
a lot. But the order had already been entered. This was on the motion for reconsideration. So in other words,
he had imposed them.
They had already been imposed. There had been a trial. He imposed this motion, these sanctions, and they moved for reconsideration. And he thought to himself, I'm going to tell you what I think the judge thought. They want to appeal this. And because the Court of Appeals hasn't been that strong. So I'm going to make a bulletproof order. So the Court of Appeals knows exactly how I used my judicial office to the letter of the law appropriately in sanctioning this firm.
Yes.
And he sanctioned the firm, by the way.
That was
big.
It's different. It's a big deal.
And we'll talk about that.
It's a big deal.
But why don't you give the overview of what happened in this?
Well, I mean, what happened is what you described happened in that case of yours, which bringing in an expert late in the game and causing utter havoc in a complicated trial that has been litigated for years. And the plaintiff's attorney in the case was just livid. And the judge realized that the chaos that their actions produced. And what was happening is that it appears that the defense did this at the behest of their client, that the client said, go ahead, wreak havoc, and we'll take care of it. And what the judge is saying, if you do that, sure, you're following your client's advice, but you as the attorney are now on the hook as well, including the attorneys who weren't actively involved in the decisions, but stood by and let it happen. That's basically the nature of the order. And
so it happened.
So what happened is that he sanctioned, make sure I get this right, Mr. Fogg, Ms. Harris, Ms. Branscombe, and Mr. Upshaw shall make a payment to the King County Bar Foundation in the amount of $2,500 apiece. And then Mr. Maldonado, Ms. Blackwell, Ms. Madden, and Mr. Bonney are hereby formally reprimanded. And, you know, this is where I think, I don't know the reprimanded lawyers. I know Lucio. This is where I think I think that, can I be candid?
As long as it's not defamatory.
No, I think it's a little bit cowardly for a firm to allow young lawyers to get reprimanded because they stood by and did not actively involved in the decision. The lead lawyers, the ones at the top of the food chain, the power brokers, made the decision. I guarantee you these lawyers didn't have any involvement in those decisions. I guarantee you they were not the ones in those rooms making those decisions. And for them to allow this to happen, I would have walked in. If I was one of the main lawyers, I would have walked to the judge, say, Judge, sanction me, reprimand me, not them. They didn't do anything. The power structure of my firm is that although they're in there getting paid by my firm, I am the one who decides. The buck stops with me. And I would have put my reputation and career on the line before throwing young lawyers under the bus, especially a lawyer of color who is trying to find his footing in the legal community. I just think that that's feckless, honestly, and it's cowardly. That drives me nuts about the order, and I'm really upset about it because it impacts their careers. You know, Fogg and those guys, they got a ton of money. Those are lawyers of privilege. They don't have to worry about it. $2,500 to the King County Bar Foundation. So I'm really upset about that.
I agree with you, but I'm also not going to let those other lawyers off the hook.
Okay, why not?
And
Push back.
I'll tell you why.
Yeah.
It's just like you have a choice. Ultimately, you have a choice. They made the choice to follow. They made a choice. This is how it typically plays out.
Yeah.
Person goes to law school for several reasons. One of the reasons is because they want to make the world a better place. They think it's an honorable profession, and they want to have a positive impact in the world, their communities. That's one of them. And they, especially certain lawyers, not always privileged lawyers, but many people want to come in and make a difference. And then they get to the end of their legal law school career and they have a choice. They can take the job with the evil defense attorneys. And I mean the evil ones, not really. Are there good ones? Yeah, my best friend's a defense attorney. The ones that have systems like this in place. Or they can go to a plaintiff firm, they can go to a family law firm, they can go to a criminal law firm, they can go to a probate firm, they can go to a contract firm. They chose to go into a firm like this, and then they chose to work on a case and cases where the sole objective is to crush the little guy who's trying to get justice against the big guy. So fundamentally, as a minority attorney, you are already conflicted because you know that that's not what you set out to do. But you have taken that deal because it's a guaranteed paycheck or status. It's one or the other. You get the status, you get the paycheck guaranteed from the beginning. So it's a choice. They made the choice. They're there. The judge wanted to give the sanction order for a very particular reason. They were there and they just allowed it to happen.
Okay, all right.
They were complicit.
I agree in many respects with what you're saying, Karen. Karen, I love you. But like, help me understand this because I'm totally like missing the point. How do you stand up in that room? What do you say? What do you say? You got to pay bills. You got maybe a family to support.
Yeah.
You're a young guy. What do you say? Tell me, walk us through how you would do it as a young lawyer.
Yeah. You say, I don't want to be part of this. And you leave.
I mean, I'll be honest with you. That's what I would have done. I would have walked. I would have not like done anything like this. I'm done. I'm out.
You say, I'm not going to sign this.
Yeah.
You say, you sign this.
Yeah.
Remember how I told you about the whole thing where I
Yeah.
had to go in front of that judge and they sent me up?
Yeah,
And the judge was already mad and I just had to take the fall.
Yeah.
Well, okay, I didn't know it the first time. And maybe this was the first time for some of them. They'll never forget this. Are they still there? Have
Yeah,
they
they're
left?
still there. They're still working.
Okay, why?
Yeah.
I would have a different reaction maybe if they had left. Then I'd say, you know what, Mo, I totally agree with you.
Yeah.
But you know what? They're going to justify this in their mind. Bad judge. Judge was way off. I think that there wasn't their excuse of this wasn't that big of a deal. It wasn't that bad.
That reason was brought up. Yes. Minimized it. Rationalized it. Mike, what are your thoughts?
Oh, I think that you both have a good point about what young lawyers, I mean, I feel like young lawyers, when the power brokers that you mentioned make the decision as to what they want done in the case, that the young lawyers are going to fall in line. And Karen's right. If you're a foot soldier for a firm and you do this kind of stuff, you're complicit. And you can argue that they're not as important and they don't have the power to make those decisions, but they could still leave. They could still choose to go to a better firm. They could still choose to just work on their own. And just because that might be a tougher road doesn't mean you don't have to take it. If there were no bad lawyers wouldn't have the reputation that everybody gives them.
It's true.
Or if there were a lot less, then it would be easy to know who the bad ones were.
Okay.
There's a case that I always can envision this, and it happens all the time when you see the young lawyers.
Yeah.
There's almost a fervor of like hero worship of their partner. Like, I'm on this holy mission. And the mission is, because I was a defense lawyer, is this plaintiff is trying to take advantage of this company. And we can't allow that to happen. And there's this almost a fervor. I saw it in this another trial where there's a brand new attorney and then the senior partner, and she really didn't know anything.
Yeah.
She was really pretty. She was so new. And I was like, hey, at least you're trying to mentor her. But even as the case was disintegrating around them, there was just this aura. She was never able to adjust of being able to read the courtroom because she was so focused and biased in terms of pleasing her partner. I watched it. She couldn't change herself. She couldn't see that the jury was angry at them. And she would just come out and keep doing her really nastiness.
Yeah.
To a nasty. And I'm not talking about, like I said, I like a lot of defense lawyers.
Yeah.
There's some that are super nasty. This guy is one of the nastiest ever. Nasty. And so that's what she's modeling. And thinking, and I can always remember my favorite part is when the jury verdict came in and just watching her face. his face, he knew how to keep it, but her face just went. Because even then, at the end of it, she was still thinking that they were gonna win because she was on the right side. So I hear you and I appreciate that. We got to go do the last one.
Okay, the last one,
Yeah.
which is $1 million. $1 million. It's the greatest sanction of all time. It makes sanctions great.
This is the only other sanction order I've seen. So there's been other sanction orders that have been bigger than this, and this firm was involved in one of them.
I know, but like,
But it didn't look like that. So what happened? The firm has twice been involved in cases. Both of them are appellate cases.
Yeah.
Where the defendant hid evidence. Hid it. Like in the Bear Products case, the paint case, they hid the fact. It was a class action, and it was about the fact that people, we live in the Pacific Northwest, that there was their sighting and stuff was failing because of this weatherization.
It was the stain.
Yeah, the stain.
The stain that would go on decks and on the sides of houses. It would mold.
Yeah. And then turns out that they had withheld the scientists' test that showed that there was already mold in it by the time. So the judge defaulted Bear.
What?
Yes. So for that discovery violation, defaults them. So, millions and millions and millions of dollars are paid out because they don't have a defense anymore. That was the only discovery sanction. It happened again in Magana. It was a seatbelt. It was, basically a $2 part. And they had hid stuff again in Magana. This is a Hyundai case. And the judge defaulted
them too.
So, but this is different. This is a sanctions order. There wasn't a default involved. Yeah. And the reason that there's not a default is because it didn't happen. Part of it happened a day or so before trial, and it didn't affect actually the trial outcome. And then another part of it happened after the trial. And then another part happened after the court ordered on the trial. And it was disclosure of insurance policy limits.
Yeah, they disclosed a $5 million policy early. Then 3 years.
Not early.
No. Wait.
Oh,
the first disclosure was a $5 million policy. Then nearly 3 years after the plaintiff's discovery request, on the Friday before trial, defendants disclosed that there was also 25 million travelers excess policy that applied to the claim.
Yeah.
The judge, the case went to verdict and the jury awarded $11 million.
Yeah.
Wow.
But the judge said, this affected so much of the trial. The plaintiffs were only trying to, they knew that there was only $5 million of coverage. So even if they had gotten a bigger verdict, they were only going to get $5 million. They made policy limits demands, meaning they would have settled that case for $5 million. It just changed a lot of what they were going to do. And then after the judge entered the order sanctioning them, they found that third $25 million, the third policy.
Oh, yeah. There was a second $25 million policy. And the thing is that talk to me about certified discovery responses, because the judge talks about the attorney certified the discovery responses. What does that mean?
Was it Max? Does he show it in there?
The court finds that the Cause and O'Connor attorney certified the discovery response without performing a reasonable inquiry into whether the discovery response was complete.
Yeah, so that was, and who was the guy?
It doesn't say who it was, it just says attorneys.
Oh yeah.
It doesn't name them.
So we have noticed that this has become a big thing.
Yeah. For
defense attorneys. We've been getting discovery requests and they're not signed by the company. The attorneys are signing them. But here, when you ask about insurance, we ask the attorney to certify that there is no more insurance, and the attorney in this case did the same thing. So you have to answer, this is how much insurance this is, and then I certify, because there's been other cases, it happens constantly, where they're not telling us all the insurance. So now they are supposed to certify it. Attorney certifies it. The insurance company doesn't sign this discovery. That's why the insurance company is not sanctioned.
Well, it's saying then that's right, and it says the court, but the sanction is interesting. The court therefore imposes $1 million sanction, $1 million sanction against Cousin O'Connor. Guess to be paid to whom? The American National Red Cross. And why the American National Red Cross, Karen?
Why?
I don't know.
Well, it's a pharmaceutical case.
Yeah, is it like? I mean, it's not the plaintiff. I don't know if they represent the American National Red Cross.
No, they don't.
So this is like a charity contribution, basically.
You can. Yeah, sanctions don't have to. Yeah, they can go to court funds or whatever. But read how it has to get paid.
They have 30. They have 30 days to make arrangements for this payment. The payment may be made in a lump sum or in 4 quarterly payments, but in either case, the entire amount shall be paid within 1 year of the entry of this order. If Cousin O'Connor chooses to make quarterly payments rather than a lump sum in 30 days, then whatever amount is not paid on or within 30 days of the entry date of this order shall accrue interest at 10% per annum. Cousin O'Connor shall file a report with this court setting forth a full details of payment arrangements, including the date and amount of each quarterly payment with interest, if applicable. After each payment, the attorney shall file with this court proof of payment from the Red Cross. The court is aware, that attorneys Cousin O'Connor contend that because the plaintiff's motion asked only for sanction against defendants, they did not receive notice that sanctions might be imposed upon them or have an opportunity to be heard. That's due process. Due process says you can't take something away unless you give people process to do it. Nevertheless, the court gave its ruling from the bench on January 17, 2025, imposing sanctions on the attorney. Cousin O'Connor was provided with notice of the February 28, 2025 hearing on plaintiff's proposed order. Thus, Cousin O'Connor has had adequate opportunity to file a memo and also to present argument to the court before this order was entered. Cousin O'Connor's due process concerns have been satisfied. Honorable Shelley K. Moss.
Can we just all clap for Judge Moss?
Shelley K. Moss. Bravo. Bravo.
I mean, this is just so. Wait, is this it?
Yeah, that's it. You have it in your hand.
Yeah. So it was Robert D. Lee who signed the interrogatories.
Oh, that's the lawyer that signed it.
From Cousin O'Connor. And William Walsh. So both of them. And then there's one more thing I want to say. I'm so speechless about it. This is why they sanctioned them. I mean, the legal basis. The court finds that I think it's Cousin, but who's counting? Cousin and O'Connor attorneys certified the discovery response pursuant to CR 26G without performing a reasonable inquiry into whether discovery response was complete. This is a violation. And then it says here that the withholding of the insurance is particularly egregious. I love that. It's particularly egregious because this information is only controlled by the insurance company. The plaintiff has no other way of getting it other than through discovery requests. And if the court does not require that there be a reasonable inquiry into what policies there may be in place to satisfy a judgment, then what is an incentive to produce those policies? So,
can we just talk a little bit about what that means? Like, break it down. Hey, Karen, do you have car insurance?
Yes.
Do you have a homeowner's policy?
Yes.
Do you have any other insurance policies?
I have excess.
Okay, can you do me a favor and send me a copy of the name of your insurance broker and company? I'll get them and I need to look at them.
Yeah.
That's what reasonable inquiry means.
Yeah.
I mean, basically what the judge is saying is that you didn't have the conversation, a reasonable conversation about, hey, do you have insurance? Do you have any other policies?
The judge said, this is an issue where defense counsel did not look for a policy which they would easily have found, and it was not disclosed until just before trial. Even more coverage was not disclosed until after trial. That cannot be tolerated.
Because, okay, is it possible that this is what happened? I don't know. You're a defense lawyer.
I gotta go.
You gotta go.
Pretty soon. Just finish. Denny's waiting for me.
Denny's waiting for you.
But finish.
Denny, just wait.
Wait, 1 minute.
1 minute, Denny. We're almost done. Okay. You don't tell them about the excess policy because you want to settle the case for less than the first policy you disclosed. So the $5 million, you go, oh, we only get $5 million. We only get $5 million. And then you go like, you get the settlement for $5 million, and then you go to your client and go, good thing you didn't tell me about the 25.
I mean, look
Is
at
that
how
what you
stupid.
did?
They should have settled it for $5 million. They would have saved $6 million on the judgment and then $1 million in sanctions
To the American Red Cross.
to the American Red Cross.
And a terrible order that implicates the
Yes.
Okay. All right. So sanctions. We read all about it. Hot off the press.
Yeah.
Yeah. Okay. All right. That was a good one. We did good.